Liens and medical bills. Let's say you settle the case, okay? So they're going to give you the release. Don't promise to pay all, don't as a lawyer promise that you'll pay off the liens. It's unethical. There's a formal opinion on that. You can promise to protect and indemnify in case they're not paid. You can say, your client can say they're going to pay the liens, but you as a lawyer cannot, because your client may make an informed decision to rip off the lien holders, and you can't go against that. But most defense lawyers understand that. Everybody wants their money back these days. So your insurance company and as well as the providers want to get their money back. And what I tell clients is I get as much money in the front end of the case as I can, but I also try to decrease the payouts as much as I can. So we have the lien holders, we call them up and we say, knock 50% off your bill because you had a free lawyer to go get the money. Knock a third off your bill. If it's an ERISA plan, if it's not an ERISA plan, they have medical providers have no lien at all. It's an old case called Schweiss versus Sisters of St. Mary, because you can't assign a personal injury case. It's void under public policy in the state of Missouri. But most plans are ERISA plans, so you want to make sure they prove to you they're an ERISA plan. Show you the policy. Okay, they're an ERISA plan, and they're going to say, well, we're an ERISA plan. You have to go to federal court. Well, that's not really true, because I file motion to adjudicate liens all the time in state court where I am, and because the court is kind of imbued with some authority to resolve all liens, and there's a lot of lien statutes that reference that. So most of the time I'll get them to capitulate to that. If it's a straight provider's lien, not from insurance, then I negotiate with them. You know, on a chiropractor bill, you can't charge $250 a visit. You know, my rule of thumb is $100 a visit. That's what I think is fair for a chiropractor. But I usually knock off some money. And then if they paid, and then if their insurance paid and they want to get the balance, many providers have contracts where they agree to accept the negotiated amount and they can't get any more. They'll try. St. Anthony was terrible at this. St. Anthony's used to, when you came in with insurance, they take your insurance, they find out you're in a car wreck, they'd mail back the insurance payment, and they try to make a lien for the whole amount. I fought them on that many times. So kind of be vigilant about these things. Don't just take what they're saying for granted. If you're not sure about it, ask me or ask somebody else who knows, who fights this stuff all the time. But make sure, I think we have a duty to our clients to make sure we pay as little back in the back end of the case as well as get as much money in the front end. You have the lien reduction statutes. So I'm going over, so especially like in a premises case, if you settle the case on the cheap, you have statutes in Missouri and Illinois. The Illinois one's different. Missouri basically says you pay the lien holders, you take your fee, your well-earned fee and expenses, because there are no laws that are written not to take care of lawyers. You always take care of the lawyers first, right? So you pay your fee and your expenses, and then the remainder, half goes to your client and half is split pro rata among the lien holders, okay? That's what I call the lien reduction statute. I call it the cram down statute. And so that helps you, okay? Your client gets half and those folks take half. However, insurance companies, health insurance companies, aren't part of those people. Those aren't medical providers. So what do? I lump them in with the providers anyway. And I send out a letter. And I say, you guys all get half. Here's your pro rata share. I have an Excel spreadsheet. If you want me to email it to you, email me. I'll tell you. I'll show you those letters. And you guys all get that. I send it out. I wait 2 weeks and see if anybody complained. If I don't get any complaints, then I kind of send the letter. And then they accept it, and it's accord and satisfaction, and you write them with a transmittal letter. This is payment in full, yada, yada, yada. The Illinois statute's different. I know you guys know. It's different. There's the doctors get a portion, the hospitals get a portion, but it's also a very strong statute that actually gives a little bit more to the client. But then Medicare and Medicaid are like the 800-pound gorilla that are totally separate. And so my paralegal, Casey, can speak to you more about this than I can because she's brilliant at it. Write them a letter, get a conditional payment letter, find out how much it is, and negotiate as well as you can with them. They're often you can get a good deal from them many times if you're doing the right thing. If you're trying to rip them off and take too much of a fee or have your client take too much, that ain't going to work. But but it should work. And then insurance liens and medical bills, work comp laws, it's 287.150. Settle the civil case, settle the comp case first and then pursue the civil case. If you guys, and then the last part of this is remember that you can work with other lawyers, and other lawyers either know parts about it, or if you get up over your head and you're not ready to do it, work with another lawyer to help you. That is the basics of trying a civil case.